consideration of the periodic report of New Zealand. Before the break, committee members asked a series of questions. They made comments and sought clarification from the New Zealand delegation on the cluster of issues under 1 to 13. The delegation has now prepared some replies, and without further ado, I would like to give the floor to the delegation. Having heard those replies from the delegation, I dare say there may be some follow-up questions from committee members. But at this point, it's my pleasure to give the floor to the Honourable Amy Adams, the distinguished head of delegation. You have the floor, madam.
Mr. Chairman, committee members, thank you for your detailed and thoughtful questions in response to New Zealand's 6th periodic review. As a group during the short break, we have attempted to group the questions into relevant topic areas which we will address. I have explained to the chairman that I will have to leave to attend to some domestic business at 5:30, so I'm going to begin by responding to a number of the issues to which I want to make contributions myself, and then I will hand over to the remainder of the delegation to speak to your questions, and if there are matters that I haven't picked up in the time I've spent on issues, we can certainly follow that up with you either later today or in tomorrow's session. I want to begin with the legal and constitutional framework questions that were asked and respond to a number of the questions raised. To deal with a reasonably short point first, one of the questions asked, I think it was by yourself, madam, in the early intervention, was around what we had meant by paragraph 6 of our report when we have mentioned that when we sought public feedback on our intended response to the committee's list of issues. We received your list of issues, we devised what we felt was a fair and balanced response. We gave that out to civil society for their comment, and while we were asking them to comment on our responses to the committee's list of issues, some submitters chose to raise other matters that weren't part of the responses that we were devising answers to. And that is the point we were trying to make in paragraph 6, that we were consulting on how we should respond to the committee's issues, but of course some submissions went beyond that and went into areas that the committee hadn't raised, which was simply the point we were trying to make in that paragraph. A number of committee members asked about our Bora legislation, our Bill of Rights Act, and its stated status and coverage. The first point to make is that you have quite rightly identified the way we have structured the law in New Zealand, which is that it is legislation which enshrines and codifies various of the human rights set out in the ICCPR. However, it is never intended to be a full and exclusive statement of all of the human rights that apply in New Zealand, and the fact that a particular protected ground is not present in that piece of legislation does not in any way diminish it. Our intention as a country and as a government is to ensure that all of the appropriate parts of the covenant are properly provided for in our domestic framework, and where they are properly and adequately provided under their own legislation, such as the Privacy Act, we haven't sought to repeat that framework and create a situation of confusion of laws within the Bora Act. So the Bora Act supplements and completes the existing legislative provisions. It does not seek to be a full and standalone statement of every applicable ground for protection in New Zealand. The second point in respect of Bora is that it does not enable, and nor is it intended to enable, the courts to strike down legislation. It does not have any greater status than any legislation in the New Zealand courts, nor is it intended that the Attorney General could somehow act to veto legislation going through the House. It has been extensively debated within our system in its creation, which is that it is designed to ensure that Parliament, which is sovereign in our system, has clear visibility and sight of any issues of potential inconsistency with the Bill of Rights Act, and to enable Parliament to debate and be well aware of those concerns, but reserving the right to Parliament always to be the final decision maker in what is the appropriate balancing of various rights and the constraints on the application of those rights as a demonstrably justified in a fair and democratic society. Now, in our framework, Parliament, as I say, is sovereign and is the only body that can make those rights. The intention of the Bora regime is to ensure that Parliament does so in full sight of any potential areas of concern. And as you will have noted from my introductory comments, we have now ensured that in our system of Parliament there is an additional layer of scrutiny. So not only is the House of Representatives fully informed, but the select committees are required to consider any Section 7 reports from the Attorney-General as part of their consideration of the bill and report on them. Furthermore, and as the committee members noted, there is a clear legislative requirement that in any situation of potential alternate meanings of legislative phrases, the courts are to apply the meaning that would make them most consistent with the Bill of Rights. So there is no, as I said in my opening, no intention to change the status of Bora in that respect. I would note for the committee's interest that when we carried out a constitutional review through 2013-14, one of the specific elements that constitutional review panel, which was made up of members independent of Parliament and the Executive, was asked to consult on and have what we termed a national discussion on, was around the status of Bora and whether there was a desire to see that entrenched as the sort of legislation that would enable the courts to strike down. I would note two things. One, there was no particular strong public sentiment to change the way Bora operates in our system, so that has been extensively consulted on. Furthermore, it would be a significant constitutional rewrite and change the final the weighting of the final decision-making as between Parliament and the judiciary, were we to give the judiciary the final right to disallow legislation. It is not something that New Zealand has ever designed its system around, and there was no particular desire amongst the public to see us move in that direction. The final point I wanted to make under this section was in respect to the comments around the Human Rights Amendment Act. A question was asked as to the status of the legislation. I can tell the committee that the legislation was tabled in our Parliament in 2011. It's progressing its way through the House. One of the characteristics of our system is that we have a long period for public engagement on various pieces of legislation, and we've had two elections in that period which slow down the legislative process. It has currently had its second of 3 readings in the House and is awaiting committee of the whole stage. One of the other functions or characteristics of our system is that we have a system of proportional representation, which means that every government since we changed our voting system has been a minority government, which means that every government has to work very hard to get the support of votes across Parliament. And I can tell members as the Minister in charge of that legislation that one of the issues we have been dealing with is negotiating a more widespread base of support for the legislation, which we now have in hand based on a supplementary order paper that I will be tabling. And so that legislation is set to proceed as soon as we get House time for it. The other matter in respect of the Human Rights Commission raised was around the selection of members, to which I would simply respond that it is a long-standing and broadly accepted principle that the Commission members are put in place by the government of the day, noting that governments change more often than the Commission members do, and often governments have either inherit or bequeath Commission membership, and knowing that and knowing the broad degree of public interest in the operation of the Commission, the Commission members and their appointment is widely consulted, and governments would be subject to a significant degree of public approbation were they to act in any way other than a fair and balanced process of appointment. And I am comfortable in saying that I do not believe that there is a widespread dissatisfaction in the way it is operated, which is a long-standing process across governments of many types and colours over the years. I want to turn to now talk about what I've broadly grouped as gender, family violence, roast butters and family court issues, if I can broadly relate to them as issues affecting women and children disproportionately. And you will have noted from my introduction that it is an area that I am both intensely passionate about, but also very focused on, and it is at the very heart of my work program and therefore that of the Ministry of Justice. We have, as I mentioned in my introduction and as committee members have picked up, one of the lowest gender pay gaps in the OECD, which is of course good, but the fact that there is a gender pay gap is not good. And as I've mentioned, we will always we will always head for perfection, accepting that it's a difficult road to take, but the fact that we're doing a lot better than others is not a grounds for us to be complacent in this area. A lot of work has been going on in recent years, but particularly since the Terra Nova case that was mentioned, which has required us to think about pay equity not just within a profession but comparing comparable professions. And the principle has been set out by the appellate court, and it has now been referred back to the government to work with a broad working group on the issue made up of sectoral groups, unions, various NGOs and government bodies to assess how one gives effect to that in practice. It is an immensely difficult task to work out whether, for example, you should benchmark the work of aged care workers with, for example, correctional workers in prisons, which I think was the example most used in the case. And when you start trying to work out what are equivalent female-dominated and male-dominated sectors that are a fair comparator, you can imagine that is a very difficult piece of work. The question asked was where that is at. Well, the work is going on at some pace to try and work out what the parameters of that will be, with the desire to get an agreed approach on which to calculate the equivalent payments that need to be made and not have to return to the court. But of course, that option is available if no agreement can be reached. In terms of the tangible, concrete steps that are being taken to advance the rate of women in the workforce, I can tell the committee that there are a number of steps at play, and in fact, some of the numbers I quoted in my introductory statement show the success. Success as a relative, the improvement, and certainly in the public sector, and the number of women in government-appointed boards and senior public sector positions. Certainly, and for many, many years, New Zealand has had not only an equality of women graduates in almost every course of professional study, and a number of them, my own, in the practice of law, has certainly been one where women have been graduating in greater numbers than men for some time. So certainly at the tertiary level, we're seeing that strongly. There are still some professions where we are wanting to see more women coming through. Information technology is certainly one, and I personally have a program of going to speak with girls' schools and women's groups to encourage more women to be involved in some of the less traditional women's areas. Within the other sectors, my colleague, the Minister for Women, has just announced a big program of work for women in trades. We have a very buoyant construction sector following the earthquake that devastated our second largest city. There is a huge growth in the trades and construction sector, and we want women to be a part of that. And so a considerable work program has been released around getting more women into trades and equivalent professions. And in the private sector, a lot of work and pressure is being put on through organisations like the Institute of Directors and the New Zealand Stock Exchange to require reporting and transparency around, for example, the number of women on boards, because we certainly recognise that in the private sector, the progress is not as strong as it has been in the public sector. So again, a significant piece of work targeting a number of specific sectors within the labour market. Let me just touch briefly on the family court reforms. I know in your last review you were concerned with the EB case and back in the early 2000s, the delays in the family court. We shared the concerns about the time it was taking to have incredibly significant family court proceedings dealt with, which is why we instituted a comprehensive reform of how our family court works, which was focused on ensuring that only the cases that really need to be in court go to court, and those that can be resolved outside of court are. Now, the advantage of that is twofold, or more than twofold. One, it enables parties to get resolution on matters that actually largely are not legal issues. They are relationship and custody and child rearing issues outside of the court, and therefore more quickly. Secondly, it ensures that they can do that without having to have the expense of lawyers and the like to complicate the process. But thirdly, we know that outcomes that are negotiated by the parties themselves, in which they are active participants, are more likely to be enduring than those imposed on them by a third party. But the most important aspect of that is that it has freed up the court time so that cases that really need the intervention of the judiciary can access that more quickly. I can tell the committee that since the family dispute resolution system has been in place, we have seen 83% of cases going into that able to resolve all or most of their issues. So it has certainly been effective in resolving those issues directly without the need to go to court. And as I've said, it has freed up the court process to ensure that the cases that need the court time can access it more quickly. In respect of the Roastbusters case, look, I'm always a little reluctant to talk about the process of any one particular case, because as any jurisdiction will know, regardless of the system and as strong as we try and make it, there will always be difficult cases and particular fact patterns, and it's very, you have to be very mindful, I think, of not allowing a particular fact pattern to speak too broadly of the framework more generally. But certainly, and as I have acknowledged, there have been issues in that case with the police handling of some of the complaints. But it does also highlight, I think, some more significant issues we have around the attitude of women and girls and society to this sort of violence and how it is dealt with. In reading the report, what became very clear was that the women themselves, the girls, were themselves confused as to whether or not they had consented and invited this sort of violence. To me, that speaks quite strongly of an issue around the education of young women around what they can expect, what consent means, and equally the concerns that came through very strongly were the concerns of the young women around the peer pressure they would face from not only their peers but their family were they to make complaints and to follow that through the legal system. Certainly the concerns around how difficult going through court would be was a factor in their decision making, but the chief concerns they indicated around why they hadn't wanted to come forward with their complaints, the confusion around whether or not they had somehow invited it, which of course is very concerning that they would think that. But secondly, the concern they would have that somehow they would be marked down in the eyes of their family and peers for speaking out, which to me does speak to a need for better education across our community about the absolute unacceptability of this sort of conduct, and certainly a concern around the prevalence of victim shaming in some aspects of society. I think a specific question was asked around the support that they received. My understanding of that case is that it's certainly the women or the girls concerned were offered support services. We have a very comprehensive system of zero-fault access to counselling services through our accident compensation scheme and also through our victim support scheme. So whether or not there are prosecutions, whether or not the women have made consents, they have full access to the specialised claims service of ACC and to the victim support services offered both through the NGO sector, which we fund, and also directly through government-provided services. Can I just touch on some of the family violence issues, because I'm just mindful of time and I know members will have questions and the rest of my delegation want to speak to some of the other issues. There is a strange anomaly here in that the better we do at encouraging victims to seek help for family violence, the better we do in raising societal awareness of the issue and the need to speak out and seek help, the better we do in having our systems encourage and provide meaningful ways to seek help, the worse the numbers get. And strangely, in family violence, we have come to accept the reality that making improvements in family violence will actually see the reported incidents of family violence get worse before they get better. That is inevitable, but it is somewhat counterintuitive that we would look on increasing reporting rates of family violence as in the short term a good thing. I don't think New Zealand is in any way unique that actually only a very small percentage of experienced family violence is reported, and we are aware that if we're going to make a significant difference, we have to first start by encouraging women, victims to come forward, and that really involves finding meaningful ways that provide them with the support they need. If I can digress for a moment, because this is a subject I am somewhat passionate about, one of the clear messages that have come through from victims in the space is that, and I think one of the committee members did reference this, that it isn't necessarily about providing for how, let's say, he is going to be arrested, held to account, prosecuted, put in jail. It's as much about, and that the phrase I hear a lot from the victim community is, I don't want him locked up, I just want it to stop. And so a big part of our focus is in finding ways that provide the support to deal with the offending that don't necessarily involve the criminal justice system. And that is creating some quite creative thinking in the space, and we are well into the work program. The question was asked around the specific tools and what that can mean and how we work on preventing, and the tenor of the question is absolutely right. We started by assessing the extent of our commitment in the space, and found that New Zealand is spending $1.4 billion a year responding to family violence, the vast majority of which is in the ambulance at the bottom of the cliff, not the fence at the top. And we are now going through quite a detailed piece of work of refocusing that effort so that the focus is far more on the prevention. The question raised was around the tools available. Can I touch on the tools that exist now, and then I'll give you a sense of where we see that developing? Absolutely, women and children in New Zealand have access to shelters. There is an extensive network from a number of NGOs of refuges in New Zealand for women and for children. There is a system of protection orders which are funded by legal aid, which is granted in 93% of cases for people who apply for legal aid. There is no co-charge on legal aid for protection orders, and nor is the debt sought to be recovered. The protection order system, though, while it is fundamental to our approach to family violence protection, is still one that we're seeking to improve. We've also created in recent years a new order called a police safety order, which allow police, when they come into a premise, to issue an on-the-spot 5-day removal notice to require the offender to leave and allow the victim to have time to enable a safety plan and think about long-term processes, and counselling and support services are available throughout. But as I've said, going forward, the focus is far more on looking at the causative factors, and I'm sure it is no surprise to the committee when I tell you that the causative factors, the biggest single indicator of family violence behaviours is the household that they grew up in. So these are multi-generational, intergenerational issues, and it is a significant piece of work, as you can imagine, to change communities where some of the communities I have seen, 90% of people in particular communities will have been involved in family violence. So to create a change in that process of thinking and the underlying behaviours is not something that we can achieve in a very short space of time, but certainly something we're focused on. Absolutely, there have been studies and a lot of work done around some of the drivers and the triggers, like alcohol, like economic pressures, like drug taking, like housing status, and we know that they absolutely play into it. But actually, the studies that have been done in New Zealand suggest that they are accelerants rather than core underlying drivers. And so while they're an important part, they are not necessarily in and of themselves the problem, but are certainly part of the solution. Finally, because Mr. Chairman, I'm aware that I'm chewing through the time, I did want to talk about some of the national security issues that committee members raised, and in particular around the GCSB legislation, the TICSA legislation, and the Michael Cullen, Patsy Reddy report that members referenced. Can I say in this regard, first of all, that a number of the concerns that the committee, or the questions that the committee raised around, for example, the ambit of the legislation, the oversight of the agencies, the scope of their view, the discrimination between New Zealanders and non-New Zealanders, the definition of personal information, the collection of metadata, the role of the telecommunications companies, are exactly the reasons we triggered the review process that has just landed. So the report that has come to the Intelligence Committee, which we tabled last week, I think it was, we've tabled it full and unredacted. The very questions posed were some of the questions posed by this committee, and it is certainly the view of the government that they are questions that needed to be answered. Now, you're quite right that we have not as yet signalled any government position, and that is quite deliberate. We have made it clear that a change in this regard, we believe, needs to be based on a broad political consensus, given the importance to all New Zealanders of these issues of safety, security and privacy. But we are very interested, obviously, in this independent review of these exact issues. I would like to correct some of the matters raised in questioning. First of all, we have no obligation on telecommunications companies to retain call-associated data or content. I can tell the committee that wearing my other hat as the Minister of Communications, I'm the Minister that was responsible for that legislation, so I do know it reasonably well. And I can tell the committee that the issue of data preservation and data retention is one that has not been legislated in New Zealand. We have no requirements for either. which is the primary reason we have been as yet unable to accede to the Budapest Convention, because that is one of the requirements for Budapest. We do not have that framework in place. Telecommunications companies are able to supply specific information around call associated data where there is a lawful basis to do so, either an exemption to the Privacy Act for the security agencies or under specific warranted powers. I want to make the point also that the TICSA legislation does not in any way enable or permit the intelligence agencies to collect information. What it does do is look at the enabling framework by which warrants granted under our Search and Surveillance Act can be given effect to. So agencies must first have a lawful basis for collecting any information, and the TICSA legislation merely updated the old 2002 legislation in the light of a vastly, rapidly changing telecommunications environment, recognising that it's not the old days where there was a single copper wire feeding into the house across which all information flowed. They do not, in and of themselves, that legislation, create any power to access any information. Those powers of access are set out in the enabling legislation of the various agencies, which are reviewed regularly, and Search and Surveillance, I can tell this committee, is currently being reviewed by the Ministry and the Law Commission as required under the legislation. Excuse me. Let me see what else you had asked. What the TICSA legislation does do is provide, as committee noted, a framework around network security, recognising that fundamental to any country's security is control of its core information, control of its company's intellectual property, and we all know that increasingly cybersecurity is used as a weapon of war. We have seen numerous attacks across the world on critical national infrastructure and organisations' intellectual property, and we're very aware that if the networks we are building in a physical sense are not robust, then they invite the cyber actors that we're increasingly seeing around the world to target them. The TICSA legislation is an attempt to ensure that our security agencies, who are our cyber security experts, work with the network builders to ensure that there aren't security flaws in the design of the core networks. It is a technical and engineering requirement and solution, and much that it was subject to a lot of misinformation and quite wrong information that circulated at the time. In actual fact, that the network security aspects of the legislation have been working extremely well, and the telecommunications companies have reported to me that they're certainly very happy with the way it's working, because it's enabled them to identify and address security issues, which of course are more damaging to them than to anyone. The only other point that I wanted to touch on in this respect was the issue around the breadth of the definition of the agency's powers, which was touched on in terms of how national security is defined. One of the things that we have required of the intelligence agencies in recent years is to ensure that their operations must relate to government security priorities, which of course change on a regular basis. But the committee is quite right that that can include economic issues, because in fact one of the core threats to New Zealand, as it is with any country, is the fact that we are targeted on a daily basis, as every country represented in this room would be, by actors looking to exploit bargaining or commercial positions by hacking into core information. And we are very mindful that were threat actors to access core intellectual property and economic knowledge in New Zealand, it would have serious repercussions on our country, and therefore the ability to provide for our citizens. And their ability to ensure that New Zealand is protected from cyber attack, we think is absolutely fundamental to part of our national security provision going forward. But mindful always that the extent to which those powers can be used, their appropriateness and proportionality is a core part of the very extensive oversight that has been put in place through the 2013 amendments to the legislation, and which the Cullen and Reedy review is now suggesting further amendments to. So very mindful of the fact that they are important powers that have to be very carefully exercised with a high degree of government oversight, of independent oversight. I was somewhat interested in the comment about the splintering of oversight, because in fact we have taken considerable cognizance of the community concern that the oversight be multifaceted and through a number of different agencies, to ensure that there isn't capture of the oversight organisations, much of which through the Commissioner of Security Warrants is led by judicial officers, to ensure that that judicial oversight is in place, which I think is important. and we've seen the Office of the IGIS, the Inspector General of Security, significantly enhanced under the 2013 reforms. And as I say, we've invited the reviewers in this latest report to advise us on further oversight mechanisms that may be required. What I think we can say is that we have seen a significant increase in the transparency of the operation of those agencies, their powers, their work program, their oversight, and their reporting to Parliament and therefore to the public. I think that has been a good thing. I think it's been widely welcomed, and I think it's helped to inform a sensible debate around the role of these agencies in society, the way they share information with particularly their Five Eyes partners, the fact that New Zealand is a net beneficiary of those arrangements, and we receive far more information from those arrangements than we would contribute, but that increasingly security is a borderless issue, and one where New Zealand, given its very small size, stature and budget, has to rely on the support of like-minded countries to ensure that we can fulfil our core obligation as a government, which is the safety and security of our people and our economy. So look, I know I said a few words, that was quite a few words, but I hope that gives the committee members a response to a large number of their questions. And now I'm going to excuse myself and we'll see you in the morning, but I will hand over to the remainder of my delegation to continue to talk to those matters and answer any supplementary questions you have. Mr. Chairman, thank you very much.
Thank you very much. I now give the floor to the representative of the state here in Geneva.
Thank you, Chairperson. I will just deal briefly with some additional questions about the Terrorism Suppression Act in New Zealand. I will then talk generally about some of the questions we received about reservations that New Zealand has entered, and then I'll turn over to my colleagues in the delegation to talk about the remaining issues that we were posed. So, dealing with the first of those, the Terrorism Suppression Act, we received a number of questions about that legislation, whether New Zealand has reviewed its position in respect of that legislation, and particularly about the domestic process for the designation of entities that have not been listed by the UN Security Council. So the starting point is that the information that is used for a domestic designation by the Prime Minister is all set out in full publicly online on the New Zealand Police website. The information that is used by the government to undertake those designations is all open source information. The Terrorism Suppression Act was amended back in 2007. It did not make any changes to the procedures of the designation of groups or individuals as terrorist entities, but it did change the process for how those designations may be reviewed. So the decisions to designate are ultimately made by the Prime Minister, and that decision is still susceptible to being judicially reviewed by the High Court in New Zealand. The criteria for designation are set out again publicly on the New Zealand Police website. I won't repeat that. An entity that has been designated may apply for the designation to be revoked. They apply to the Prime Minister. If the entities are dissatisfied with the Prime Minister's decision, then that entity again can seek a judicial review of that decision. And again, that information is publicly available. If there are additional questions, then we'd be happy to look at those. Just in the interests of moving through, I'll now deal with the various questions posed about reservations to the covenant. As I think many of you may know, New Zealand's long-standing policy has been to bring our law into full compliance with our treaty obligations. That said, New Zealand won't commit to do things if we know that that's not going to be appropriate or feasible. So there are a very small number of reservations to the core human rights treaties. They are monitored in terms of their continued appropriateness, with a view to narrowing them or withdrawing them when that's appropriate. I'll deal just quickly with the reservation to Article 14, which is compensation for miscarriages of justice. And the question was posed, why don't we put that into law rather than with our existing procedure? I think the short answer to that is the government believes that its existing process for compensating miscarriages of justice is satisfactory. It is an administrative procedure rather than one that's regulated, but nonetheless, the government's view is that there is a high degree of transparency in the system that we use. There are guidelines for determining eligibility, quantum of compensation, and there's also a residual discretion that rests within the cabinet, so within government ministers, of extraordinary circumstances which may apply, which may justify an ex gratia payment. So I think in the government's view, the existing system contains the flexibility that is necessary to deal with miscarriage of justice situations. And it's notable that there have been, of the 25 claims that have been made to the government since 1998, 6 have been successful and resulted in ex gratia payments, and 2 of those claims were actually justified under the extraordinary circumstances criteria. So I think that demonstrates that the system is there. It's not heavily utilised, but it is available nonetheless. Moving on to the reservation to Article 20 concerning propaganda. New Zealand law does not explicitly prohibit propaganda for war or advocacy of religious hatred, but our criminal legislation does proscribe the incitement of hostility or ill will between different classes of people if that may endanger public safety. The Human Rights Act also prohibits the incitement of hostility on the basis of the grounds of colour, race, national or ethnic origin. And by our count, there are at least 15 other developed countries that have a reservation in very similar terms to New Zealand's, to Article 20. Dealing with Article 22, protest or sympathy strikes. This issue obviously concerns freedom of association. New Zealand law since, I think, 1991 has provided that employees may not engage in sympathy strikes. Only the employees of the specific employer, their employer, may take strike action. This has been a provision that's been maintained by successive New Zealand governments, and while the government does continue to monitor the jurisprudence of both the ILO and the Human Rights Committee, I'm unaware of plans to change that provision. And similarly with the other reservations I've mentioned, I'm not aware of current plans to withdraw those specific reservations. The remaining reservation that we were asked about concerning age mixing in detention facilities, I'll pass over to my colleague Rachel to answer. But thank you very much for those questions.
Kia ora, Mr. Chair, Committee. I will be responding to Article 10. I'd like to point out that New Zealand is actually being compliant with accommodating prisoners under the age of 18 within prisons, and with respect to male prisoners. New Zealand has been compliant for many years in this case. We have designated youth units that can house them so that they do remain separated from adult prisoners. With respect to female prisoners, the numbers are very small, probably less than 5 at any one time, and potentially are spread throughout the country. So in relation to ensuring that they can attend their court appearances and maintain contact with their family and other support networks. So from a practical perspective, it's not easily presented to have a separate youth unit for young women prisoners, because that would invariably mean that they would probably be housed on their own. So when we have situations such as this, we have close monitoring and supervision by staff and other support networks. The young people are screened around their vulnerability and are sure that they're associated with other adult prisoners that would pose for little risk to them. There are occasions where male prisoners under the age of 18 may be mixed, and that's in relation to when they appear in court and possibly when they are apprehended by the police. In those situations, it is sort of very small time that they would have any association with any adults, again under very close supervision and continuous assessment for their own vulnerability and who they are mixing with. The good news in respect to this is that youth crime is dropping considerably. Our Honourable Minister mentioned that youth crime is dropping around by 36%. So the demand for young people's beds within the prison environment continues to drop, which is a very good situation for our country.
So I'll now turn over to my colleagues from the Ministry of Justice who wanted to elaborate on a couple of the remarks that our Minister made on some constitutional issues. Thanks.
First of all, I should probably apologise for not being as eloquent as my Minister. But we just wanted to supplement a couple of points that she made. She talked about the constitutional arrangements and how it is an important constitutional principle for New Zealand of parliamentary sovereignty. We just wanted to clarify what we're saying is that the courts and the Attorney General provide advice, but in the end, Parliament is the final arbiter of whether something is a justified limitation to the breach of that right. Now, what we've had, and referring to another question that was asked, was the courts have established in jurisprudence quite clearly that under New Zealand law, the courts are able to interpret legislation consistently with international obligations that that legislation was designed to implement. So there was a question earlier about the definition of human rights standards in the GSB legislation. So that would mean, in our view, that the courts could interpret that to include compliance with international human rights obligations, not just the Bill of Rights Act, but also potentially the Human Rights Act and the Privacy Act. So there is that expansion. It also means that the way the courts will interpret relevant legislation like the Search and Surveillance Act, the Bill of Rights Act, they will look to the comments of the committee and other relevant international bodies for the relevant international conventions when they are considering these issues. In fact, on the declarations, there was another question about the Human Rights Act and the Bill of Rights Act. So if I could just take time to clarify how the system works. Under Part 1A of the Human Rights Act, there is a legislative power for the tribunal and therefore the courts to make declarations of inconsistency. That means they can make declarations of inconsistency that a piece of legislation has unjustifiably breached the right against discrimination. It also means that that tribunal can look at policies that aren't legislated and actually make relevant orders to prevent that happening. Under the Bill of Rights Act, the courts have established, the Bill of Rights Act doesn't have any specific legislated remedies, but the courts have developed various remedies under the Bill of Rights Act. For example, they have created the right to public law compensation under the Bill of Rights for a breach of the Bill of Rights Act. And one of the remedies they have created under the Bill of Rights Act jurisprudence is the ability to make a declaration of inconsistency. And in fact, one has been made, and that is still going through the court process. We in New Zealand view the current situation as actually a sign of New Zealand's continuing robust discussion about these things. There have been so far through the Human Rights Act process 3 declarations, 2 of which have led to law change or processes that could lead to a change of policy and law change. One, actually the last one, was only made about a week ago, so we're still thinking about that one. So of the 4, we think that demonstrates that the government does take these declarations seriously and there is thought going in, and so that dialogue between the executive, parliament and the courts is happening, is alive, and it is well. I'll now hand over to my colleague to talk about, there was a question I think about the different definitions between race, ethnicity and religion.
I just want to briefly address the question of religion in the Human Rights Act, specifically whether Section 61 and Section 131 of the Human Rights Act, which relate to racial disharmony, could extend to include religion. Those sections don't cover incitement of religious disharmony, but there are a couple of points to make there. First of all, that religion is a prohibited ground of discrimination in the Human Rights Act, so other forms of unlawful discrimination are covered under the regime in that Act. And the second point, which relates more to Section 131, which is a criminal provision, that provision is not often used, largely because the activities that it covers are also covered by other criminal offences. And the important point to make there is that under the Sentencing Act, it requires that any offence committed partly or wholly because of hostility towards a group of persons, including race and including religion, then a court must consider that an aggravating feature in sentencing. So that means that any offence where you have a religious or a racial motivation can be covered by that provision. So that would include offences of violence or threats of violence against a particular group, including a racial group or a religious group. Thanks very much.
There were a number of other questions that committee members posed to us about Māori participation in the labour market, religious minorities, migrants and related issues. I'll turn over to my colleague Steve Stewart from Immigration New Zealand to deal with those. Thanks.
Thank you, Chair. I think it's important to understand that migrants make up about 1/3 of New Zealand's workforce. So their well-being is important for New Zealand's overall social and economic performance. And in fact, we expect that figure to grow in the years to come. I'm pleased to say that migrants in New Zealand are generally well educated and have favourable labour market outcomes. And ensuring that migrant workers receive equal and fair treatment in the labour market is a very important priority of the New Zealand Government. To strengthen access to the labour market for migrants, the Government is focusing on 4 key aspects of migrant life. First, ensuring migrants are treated equally in the labour market. Second, ensuring good settlement services and support are in place for new migrants. Third, ensuring good settlement services and support are available and in place for refugees. And finally, we are very focused on preventing the exploitation of migrants. The key principle here for the employment of migrants is that they receive no less favourable conditions than New Zealand nationals and their permanent residents. Employers are obliged under the Human Rights Act 1993 and the Employment Relations Act 2000 to provide protection against discrimination in employment. In terms of enabling migrants to settle and integrate into the community, New Zealand Migrant Settlement and Integration Strategy was approved by the Government in 2014. The strategy outlines the Government's approach to settle and integrate new migrants so they make New Zealand their home, participate fully and contribute to all aspects of New Zealand life. The strategy identifies 5 measurable settlement and integration outcome areas. These are employment, education and training, learning the English language, inclusion, which includes addressing discrimination, and health and wellbeing. Phase 1 of the strategy has been completed and a review is underway to determine whether available services and information provided to migrants is properly targeted and will set up the next phase of the strategy. Just turning to migrant exploitation, this has been an area that has been a keen focus for the government over the last few years. The migrant exploitation strategy is aimed at ensuring New Zealand has fair treatment of migrant workers. The immediate outcomes sought by the strategy are supporting exploited employees, holding exploitive employers to account, and helping migrant employees and their employers understand and act upon their rights and obligations. The strategy is supported by an education campaign for migrant employees and their employers. The focus in terms of the action plan is to target employers to ensure they are complying with their obligations under the various pieces of legislation. The Immigration Amendment Act of 2015 makes it an offence to exploit temporary migrant workers. Previously, it was only an offence to exploit unlawful workers. Employers who exploit temporary workers face a jail sentence of up to 7 years and a fine not exceeding $100,000 or both. The Act also created a new offence for employers who exploit legal, temporary or unlawful workers and are reckless as to the immigration status. Both these offences carry jail sentences and heavy fines. In addition, exploitative employers who hold a resident visa will be liable for deportation if the offence is committed within 10 years of gaining residency. So we have strengthened considerably the sanctions against employees who threaten to exploit migrant workers. In terms of Maori and Pacifica in the labour market, the Minister touched briefly on the focus on the educational outcomes of Maori and Pacifica. The plan there is to integrate the early learning education of Maori and Pacifica so that they are work ready when they leave school. In terms of the labour market, a number of initiatives are in place to ensure that Maori and Pacifica have opportunities in the labour market when they leave school. A strategy of the Maori economic development sets out 6 goals for supporting Maori: greater educational participation and performance, skilled and successful workforce, increased financial literacy and savings, government in partnership with Maori enables growth, and active discussions about development of natural resources, and Maori as a driver for economic growth. In addition to this, the Pacific Economic Strategy of 2015 to 2021 was released in December last year. This strategy supports Pacific people to contribute to and share New Zealand's economic success by stimulating Pacific people's economic participation, and looks to involve Pacific people's involvement and contribution to New Zealand's economy through greater participation, through community involvement, and through additional learning. Moreover, recently the government has engaged a sector workforce engagement program. I'll give you an example of one such program, but this is designed to stimulate jobs in the labour market in key areas of unemployment. In Auckland is high levels of Maori and Pacifica unemployment. The Auckland International Airport currently has a construction program of 30 years duration to build additional runways, terminals and infrastructure to support the growth of that region. In addition, the District Council is providing new roads and infrastructure to support, again, the growth of Auckland. A sector engagement program has been set up to join up with those companies as well as the key construction companies in that area to prepare the workforce of Auckland, particularly Pacifica and Maori, so that they are work ready and able to take jobs when they leave school. This will enable the learning that the students get at school to translate directly into jobs in the workforce and therefore make them contributors to the New Zealand economy and the Auckland region. In addition, Te Puna Kōkiri creates a range of cadetships for Māori to stimulate Māori into the workforce. Since its inception in 2009, 1,247 cadetships have been made available through this cadetship initiative. The level of interest from employers has increased as the value of the initiative has been recognised by sector leaders. In 2014, 15 employers took on 350 cadets. The number of cadets remaining in employment has increased since 2009 from 71% to 100% and 95% in 2014-15, showing the success of that program.
So, Chairperson, there were just, by our estimate, in fact, 3 questions that hadn't been answered. But with your indulgence, Sarah, I will ask my colleagues from the Ministry of Justice just to deal with those very briefly, so there's still time for supplementary questions. They related to the implementation of past recommendations by the committee, the issue of passport cancellation, and New Zealand's National Action Plan. So, gentlemen, if you could deal with those briefly, that would be great.
Thank you. I'll speak to the responses to committee views under the first optional protocol and also to the National Plan of Action. Looking first to the views of the committee, New Zealand doesn't have any formal mechanism for considering the views of the committee on the first optional protocol, given the small number of cases where there's an adverse finding against New Zealand. However, we carefully consider all the views of the committee and formulate appropriate responses. The findings of the committee in particular cases are always reviewed by the Crown Law Office or by relevant government agencies. They provide advice to the government by reporting to responsible ministers and, if necessary, reporting to Cabinet seeking agreement for a government response. On the National Plan of Action, the question that we were asked was specifically about the first National Plan of Action and what lessons had been learned from that, and there was a specific point made about the fact that there was a gap between the first action plan and the second action plan. So the first National Plan of Action for Human Rights contained 178 priorities for action, which, although there were some successes there, did make it difficult to implement. When the first National Plan of Action expired, the Commission sought an independent review of that process. The review identified matters to consider when developing the next action plan. This included earlier engagement with government to identify priorities, establishing a framework for implementation and monitoring, and fewer priorities for action. That informed the Commission's approach to the second National Plan of Action. The process did mean that there was a gap between the first National Plan of Action and the second action plan, but as I can see from your comments, I think we can agree that that's led to a better product in the second National Plan of Action. Thank you.
Thank you. Actually, I've just realised there were a couple more, but I can address those as well. So, on my list, I should mention some of the questions referred to the special advocate process. We needed to mention that the government had initiated through the Law Commission a review of the use of classified information in courts, which is linked to the use of special advocates, and the Commission has delivered its report, and that's currently being considered by the government. So there could be changes resulting from that, and so I thought that would be relevant to your considerations. On the question, there was a question about the recent foreign fighters legislation and the cancellation of passports and a concern about identity documents. Just wanted to clarify that in New Zealand there are actually a range, I guess, of what we use is national identity documents. So domestically in New Zealand, you can use a birth certificate, a driver's license, and a passport. So the cancellation of a passport does not necessarily mean that domestically you don't have any other way of proving your identity. If you're concerned about what happens to New Zealanders overseas if we cancel a passport, well, the whole point of the obligation that we were trying to meet under the UN Security Council was to stop people, New Zealanders potentially wishing to participate in the fighting overseas, to go to those countries and travelling. So the removal of a passport or cancellation of a passport of a New Zealander overseas does not prevent that New Zealander going to the local New Zealand consulate or embassy to get an emergency document to allow them to travel back home to New Zealand. And that is effectively what we were hoping, well, desiring them to do. There was a question about the Terrorism Suppression Act, and a note that previously the government had, through the events of Operation 8, indicated that they had concerns with the way the TSA was operating. I would just like to clarify that the issue in that case is one where the government was looking at whether a group of people had done enough to be viewed as preparing to do a terrorist act under the legislation. And effectively, the standards in that legislation meant that the Solicitor General decided there was insufficient evidence to proceed with that prosecution. So as this committee will know, that's a very, very important criminal law and civil liberties question. And so therefore, there has been no change to that legislation until the government figures out exactly what the right balance is there, which means that the government is erring on the side of caution in that case. There was lastly a question I recall on how we might be preventing the cyberbullying and the incitement towards racial hatred and participation in terrorist activities. So yes, the government recognises that it's not just a matter of creating laws like the Harmful Communications Act. There is preventative efforts happening through the Office of Ethnic Communities. There is very good work happening in the Ministry of Education, all designed to talk to young people and deliver counter messaging to young people about how the pathway to violence is wrong, how cyberbullying is wrong, educating young people on how to deal with cyberbullying. There's an enormous amount of preventative education and working with communities to prevent those things from happening, not just creating a criminal law response to it. Thank you.
Muchas gracias.
Thank you very much to the delegation for their replies under this first cluster of issues. I imagine that some colleagues who ask questions will have some follow-up questions to ask. I have 3 people on my list. The first is Mr. Fatala. Mr. Fatala, please.
Chairman, and I would like to thank the delegation of New Zealand for the information they have provided to reply to our questions. But I was not able to catch a clear reply on my question related to training of unemployed migrants equally to the training of unemployed New Zealanders. Because I'm not speaking about the training that they are getting by the employers before getting employed, because in the report there is an obligation that, or not an obligation, but anyhow it's mentioned that you train the New Zealanders, but there is no mention about training of migrants. Thank you very much,
pass the floor to Ms. Cleveland.
Mr. Chair, and because this is the first time I've taken the floor, I would like to welcome the delegation from New Zealand and express our appreciation for the information you've provided. My questions also relate to the treatment of migrant workers, and I appreciated the efforts that you've taken and the detailed response you gave. My specific question was with respect to your criminal laws establishing the offense of exploiting or attempting to exploit migrant workers. How many cases have been brought to date under those laws and what the outcome of those cases has been? And then relatedly, I had a question regarding the treatment of crew members on foreign flagged vessels that enter New Zealand waters. In your report, you informed the committee that through the Fisheries Amendment Act of 2014, you've worked to strengthen the monitoring and enforcement of human rights standards and minimum treatment standards in this context. And so in that regard, I would appreciate information regarding whether or not crew members themselves are provided with information about some complaint mechanism to the state party, whether there's a right of redress under the law and remedy for crew members to seek compensation under the law, and if so, to what extent crew members have actually sought such remedies to date. And then finally, whether legal aid is available to facilitate victims of fishing or labor standards violations in bringing claims in this context. Thank you.
Thank you very much. Now I pass the floor to Mr. Shani.
Thank you, Chair, and I thank the delegation for their copious answers. Two issues I don't think I received an answer to are the issue of expedited legislative procedures for some of the counterterrorism legislation, as to why was an expedited legislation process selected. And I'm also not sure I received an answer on the police register aspect of the network operators and their need to provide information about identity of customers to the police when they have infrastructure, also an infrastructure service to provide. I just want two clarifications. On the minister responded to my question on the call-associated data and made the clarification that it does not address the contents of the communications. Am I right, however, in understanding the call-associated data does contain metadata, namely data about data, namely who made the call, when was the call made, how long was the call, who was the recipient, if the call was transferred, how was the transfer? And my question related to the need to whether the law does obligate the network operators to preserve that sort of information, namely not the contents of the communication, but information about the communications. And finally, I appreciate the answer about the cancellation of passport, but my question was rather on the cancellation of identity certificates. This is Section 3 of the Countering Terrorist Fighters Act. Section 2 deals with passports, and I did see your answer about the emergency, but I was simply wondering, what does it mean to cancel a certificate of identity for a person? Does it mean that it doesn't, I assume it doesn't encompass birth certificates, but maybe driver's license or passport or some national identity card, and I just simply want to know how can a person then manage to get on with his life in New Zealand if he or she does not have these sort of documents.
Thank you very much. Now I pass the floor to Mr. Iwasaba.
Thank you, Mr. Chairperson. I thank the distinguished delegation for giving responses to our questions. I have 2 points. First, reservation to Article 10.2b and 10.3. We had explanation as to why the reservation needs to be maintained, but I don't think we had explanation on why there has not been progress since 2010. The second is the family court reforms. A report of Radio New Zealand published on 2nd of this month, 2 March 2016, is entitled Family Court Reform Appears to Have Failed. This report gives its concerns. If the delegation is not familiar with the report, maybe you can review the report overnight, and I would appreciate it if you could give us responses tomorrow morning. Thank you.
Bien.
All right, thank you very much indeed. We have 1 minute remaining, and I have 2 speakers requesting the floor. Perhaps the most sensible course of action at this point, Mr. Rich, would be to suspend our dialogue at this point and then allow colleagues to speak tomorrow morning without the pressure of time, given that we have just a few seconds remaining. And once they have asked their questions, you will have the opportunity to answer them and then hear the second cluster of questions under the next listed part of the list of issues. Allow me to thank once again the interpreters for eating into their evening break. It's 6 p.m. and at this point we will bring the session to a close. Enjoy your evening, have a good rest. We will see you again here at 10 a.m. tomorrow.